This is the third lecture in the legal process class. We're going to be talking about advocacy and an overview of ethics. I want to break down when you think about the process of going from some sort of conflict all the way through a jury trial, that there are many stages in between. So I'm breaking it down to stages. We don't normally refer to it as a stage, but it's helpful to be able to think of them in terms of this now follows that. So obviously there's going to be some conflict, right? If there's some conflict, I don't care what area of law, there's got to be some conflict. Now that conflict in stage one has to be written out, because we're at the point where we're beginning to engage. You've got an attorney, I've got an attorney, and we're going to begin to engage the conflict, right? The whole idea is obviously to keep this from going to trial, a jury trial, and taking months and months and months and a great deal of money in order to get to that point. So now I'm not going to really spend much time talking about a criminal trial, because that has a different, not so much process, but we'll touch on it, but there are certain things about that deviate. And most conflict that we're interested in is really non-criminal in nature, torts and the like. So stage one, there's always some written documents, right, that are going to go back and forth between the lawyers. The lawyer for what could become the plaintiff would send a written document of sorts, right, correspondence, over to the attorney or to the prospective defendant. So your client comes to you and says X has happened. Lawyer says, okay, let's hear the story, figure out what the important facts are, figure out what the best approach might be, and then writes a letter, a document, something, and sends that to the person, in a legal matter, obviously, to a person who then gets that, a complaint, and says, okay, now I've got to respond to this. So let's assume the person is not going to do a pro se. They're not going to respond on their own. They're going to go to an attorney. That's what we're really interested in, that legal process, as it manifests itself normally. So there is correspondence back and forth. The person goes to get an attorney. The attorneys start going back and forth. Now, keep in mind, attorneys deal with other attorneys. That's what we're interested in. And that means that there's probably going to be a repetition in terms of those two attorneys ending up perhaps in another situation, another conflict that they may have to try and resolve, or it may go all the way to court, in which case there's a judge and the like. So you have to think, if you're an attorney, the process is repetitive. So that should govern your behavior. In other words, I'm going to come in and I'm going to deal with that particular attorney in that particular court again, or certainly in that particular court. And I don't want to be seen as someone who sort of fudges the rules or manipulates things or insults the court. So lawyers are always governed by that in the back of their heads. They're always thinking in terms of that, or they should be. So in that stage one, you get the documents going back and forth, and maybe it gets resolved there. Maybe the parties come to some sort of agreement, right? Now, sometimes a letter will be sent to an individual. We'll just say it's a letter. And really the dollar amount, because that's what we're interested in talking about at this point, the dollar amount is so small that it's really not worth the lawyer's time, or really the plaintiff's time, but writing a letter, why not? It may result in that person sort of paying back rent or something along those lines, in which case the issue is the conflict is resolved, the lawyer's gotten something for his client, and the other side has ended the conflict. All right, so in stage two, now, in stage two, they haven't worked it out in stage one, which means that the lawyers have not been able to resolve it. So now they begin to move in stage two, and now they're moving towards litigation. Again, at this point, they still don't want to litigate. That's a long, arduous process, and the outcome is uncertain. So you always want to resolve this at each of these stages or phases. So in the second stage, formal litigation begins, and there are pleadings and a complaint, and then an answer. So basically, We'll get to all of the specifics of that. But at this stage, what we're doing is we're now writing down for the court what we want to have happen, or laying out all the particulars, possibly in greater detail. So a complaint is, here's the conflict, this is what's been done. There's got to be time for an answer to that complaint, saying how they're going to respond. Don't forget, they've already gone through some, in stage one, some negotiations back and forth. And so people are familiar with it on both sides, and now it's going to get more specific. And so the other side has a chance to put in an answer and a counterclaim or a complaint of their own. All right. So when we talk about the stage two, we're beginning to look at the rules of admissibility. We get to stage three. We're now looking at motions. Motions are, you're really requesting something of the court, right? The judge to take some action. Again, this is the third opportunity. Now they're in court before a judge where they can submit to the judge a motion asking the judge to do something. Typically, in the beginning, it's going to get rid of the case, right? That there's no case here, just be done with it. It's a good idea to run it up the flagpole. It ends the litigation and the like. But once you get to that stage, asking the judge for actions, examples of that would be you want the judge to act on a rule, of evidence. That can't be admitted. There are the rules of evidence, which, by the way, legal scholars, lawyers, judges get together and they look at what evidence should be allowed to be admitted at trial. Now, again, with all things that are legal in nature, these are not hard and fast rules, and not every court in every state or county is responsible for necessarily following those rules of evidence. They're going to obviously stick close to those, if not really just employ them. And there again, there are decisions made about, is this a felony or a misdemeanor? When can you bring evidence in about a person's past behavior? In a criminal trial or in some other case. So, they want the judge to rule on the merits of the case. As I've said, there's really no case here. They want to get rid of that. But let's just say that fails. Now you're moving into, the next stage, which is going before the court and the jury and trying to resolve the issues at hand. Now, I'm going to jump ahead for a second. Failing that, something happens, there's a decision by the jury, and the losing side believes that there's some issue here that has made that decision improper or inconsistent or something. There's something wrong with that decision. That would be jumping. Stage 4 is actually a trial. Stage 5, which is the appeal, right? And so you go through the pleadings, the motions, and then you end up at appeals, and the appeals follow sort of the same schedule, right? The party seeking relief, and that means seeking reversal of the lower court's judgment, files a complaint, a petition, or an open brief and says, hey, we're appealing this case, and they lay that out. The opposing party responds with an answer. Seems it's very familiar, right? Saying, no, the lower court decision should stand. And they answer that brief. All right? And then finally, the party who filed the petition or opening brief generally has an opportunity to file a reply to the brief addressing their particular issues. And so, again, what I want to stress here is, in the law, when you think about it, a lawyer and the law's stock and trade are words. And so there's always a lot of verbiage. In law school, the writing class, although laborious for a lot of people, is critical because it teaches you how to write like a lawyer. And that's different than you might write in some other venue. And there are differences even in the field. Office memoranda, memorandum is compared to a brief before the court, a motion. All of these things have ways in which they are structured. And the courts are accustomed to seeing them structured that way because over time we've realized, look, this is the process we need. Again, keep in mind that, and I want to put evidence aside, but please keep in mind that evidence is a key part of all this. And again, the rules around evidence are constructed by people that understand not only the legal process, but understand the goal of the policy, right, that's now in conflict. Remember, the goal of all law is in some way to deal with human behavior, a policy that deals with it, and the like. So the idea is that when you're writing for the court, depending upon where you are in that process, there's an expectation about how you're going to approach things. So the first thing is that whatever you write and however that you act in during the process, the court expects to see that you're reasonable, right, and that you're only operating in good faith, not trying to manipulate the process, not doing anything outside the process, and that basically you're giving full disclosure. You're not holding anything back. The idea here is it's adversarial. Both sides come together. It's a fair and open and reasonable process where both sides operate in good faith. Again, this goes back to the point that lawyers are going to probably repeat this process. They're going to be in that same court, perhaps, before that same judge, or with that same attorney. You can't afford I guess you can afford, but it comes at a price, to alienate the other attorney by doing things that are not reasonable, doing things that you as an attorney might think are clever or would sort of win the day, but they're really unacceptable. So let's just look at these in sort of one by one. As an attorney, and I'm reading from page 345 now. As an attorney, you owe a duty to your client to advocate her case vigorously. In carrying out this duty, you will often argue for creative extension of existing law or for replacement of existing law with new rules. Words. Attorneys will look at that, and they're going to either do one of three things, really. They're going to take the existing rule and show how that applies here. That's one. They're going to ask for maybe a different interpretation of that rule, an interpretation that's not taken place over time. Keep in mind that that's how we refine what a statute or regulation actually means. By the cases that come up, we begin to define it more specifically. So you're asking for some change in that, or what you're really doing is saying, there needs to be a new rule here altogether. This doesn't fit, and there's some issue with it. So you get the Federal Rule of Civil Procedure, so it's a Federal Rule of Evidence. We're talking about the Federal Rule of Civil Procedure 11, that's what it's called, requires attorneys to certify that their written advocacy is supported by reasonable investigation of the law and facts and is not advanced for an improper purpose. You're going to the court is not going to do the heavy lifting for you. Tell us why. You've done your homework. Tell us why we should consider this case in this light and why we should take your particular slant on it and support that in decision rather than something else. So I'm going to read you, again, it's page 345. I'm going to read you, exactly what one of these looks like, right? The Federal Rule of Civil Procedure 11. So representations to the court, that's what we're talking about. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party, okay, means that they're doing it themselves, certifies that that to the best of the person's knowledge, information, and belief, formed after an inquiry, reasonable under the circumstances. Circumstances vary. You may not have a lot of time. You may have a great deal of time. So there's reasonableness. It's always about reasonableness, right? One, it is not being presented for any improper purpose, okay, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The court does not want to see that manipulation. Oh, you're going to drag this thing out because you want to raise the cost. knowing that the other side can't bear up under those additional costs. So you're really running them out based on the cost and not based on the legal arguments. And if the court gets wind of that, thinks that's what you're doing, that's problematic. Okay, the second thing is the claims, defenses, and other legal contentions are warranted by existing law or by non-frivolous argument for extending the law, right? Modifying or reversing existing law or for establishing new law. In other words, the claim that you're making, right, has to be there and must rest upon existing law. It's got to be a non-frivolous argument. It can't be a frivolous argument that you're making. And you're doing what I said before, looking to extend, modify, replace some existing law that you think is no longer applicable. In this case, the third is the factual contentions have evidentiary support. There's evidence to support your argument. You can't conjure these things up. How do we know? What evidence do you have? Well, I know they did it. Not good enough. Not good enough. What evidence do you have? How can you demonstrate that this person actually did what you're claiming they did? You need to have documentation or something, witnesses and the like, that can support your argument. It says evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. In other words, we know that there's evidence there. We are in the process of gathering that, and we know that that will support our argument. There's additional evidence. We're waiting to get that. Some of it will come out of trial, witnesses, and that sort of thing. Fourth is denials of factual contentions are warranted on the evidence or specifically so identified are reasonably based on behalf of, or a lack of information. Okay, you don't have factual contentions here, right? And on the evidence, you can't identify it, so it's reasonably based on belief or a lack of information. What we know, or what's reasonable to believe, it makes sense that what we're claiming happened actually happened. So Rule 11 authorized the judge to impose this is a quote now from the rule, an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. So the judge says, wait a minute, I see what you're doing, it's improper, and there's a penalty tied to that. Rule 11 also contains a quote-unquote safe harbor provision that permits a person responsible for a Rule 11 violation to escape those sanctions, right, by withdrawing the offending claim or defense, usually within 21 days, according to Rule 11, set by the court. You look at this, you come back, and you say, we're pulling it. The court doesn't want to penalize. It wants a fair and reasonable trial. Keep in mind that you keep pulling things like this, where the court is going to say you violated something here. You're hurting your reputation and your candor and the quality of your work. Better that an attorney does all this and doesn't win the day, okay? Right? Then they win the day, but they win it through a manipulation. That travels very fast. Okay, now the question becomes, how are you going to go ahead and bring together, some understanding of, or some presentation to the court of what you're building your argument on. Remember, you got to build it on some statute, regulation, something that, case law that says, there's been a violation here. You're going to have to go back and you're going to have to base that advocacy on some argument that, the court can look at and reasonably say, okay, excuse me, that you've got something here. We'll leave it at that for now, right? All right. So you don't have to make, in this case, you don't want to make, and you don't have any duty to argue your opponent's case, right? Or even to present a balanced analysis. You don't want to do that. Not when you're in this venue. If you're writing an office memorandum for your partner or what have you in a firm, you're going to want to do that. Because what you're doing is looking at the case itself, and we'll get into this, the particulars, the facts, And what the firm wants to know is, do we take this case? We want to win. What's the likelihood of winning, right? It's well known that in, for example, car accidents and the like, that you have a greater chance of winning something if you can show that there was real damage done to you. Psychological damage is really hard to prove, right? Because what might damage someone psychologically may not affect someone else at all. And how do you measure that, right? So typically they look for physical evidence. And so you'll often see people, going to get operations. I'm not saying that they're lying or it's faulty, but certainly that's a physical thing. How to go for an operation. My knee's never going to be the same. I had to go through 6 months of physical therapy. I'm in pain always, and that pain can only be mitigated so much by drugs. And the court might look at that and say, okay, well, this person's 28. They no longer can be involved in the work they were before, or the career they were before, because it requires the use of, say, that knee, a lot of lifting or what have you. And so the court, especially in awarding things, thinks about that. It's always the case. Divorce law, whatever, the court's going to look at, where the person is and some sort of reasonable assumption about the likelihood of them, say, in a divorce, if one party or the other hasn't worked, their entire married life. Question is that person able to go back to school, maybe get a valuable skill set that they can then use in the workplace? Or is that person already working, let's just say part-time, but has the opportunity to go elsewhere and get a full-time job? Or there is a skill set already there that's in demand in the marketplace. That would limit the amount that, say, the working spouse, different jurisdictions are different, would have to give over to continue to support the spouse. So you're always looking for fairness, and you're looking to minimize damages. You're not looking to just pull things out of the air here. You want things to be fair and to be rational. So, all right, the idea here then is you have to remember that attorneys are officers of the court. They represent the court, if you will. And so they're expected to, carry themselves in a certain way. If you look at the American Bar Association's model rules of professional conduct, they require every advocate, attorney and the like, to disclose significant authority adverse to the advocate's arguments. So here it is. A lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Again, fail to disclose, a lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction, and I'll explain that in a second, known to the lawyer to be directly adverse to the position of the client and not disclosed by the opposing counsel. Right? All right, the scope of this duty depends in large part on the interpretation of the phrase, quote-unquote, directly adverse. The most sensible approach to disclosure is one that maintains your credibility as an advocate. If adverse authority within the forum jurisdiction is sufficiently analogous that the court would consider deciding a case, the judge or the judge's law clerk likely will have already been aware of it, right? Discovered that authority sometime before the end of the proceedings. Judges don't necessarily depend just on what the lawyer is going to present. So what we're talking about here is when we talk about the particular area or the fundamentals of this, the jurisdiction is important, right? You need legal authority, and what you're looking at is there's a controlling jurisdiction. Now, let me explain how that structures itself. In every state, in every county, in every city, in every, if it's on appeal, in every federal district and in every federal appellate court, there are jurisdictions where their cases, and sometimes the law, is basically controlling in that jurisdiction. So lay it out, we'll get into this a little bit more later, but if you lay it out, if I'm making an argument in jurisdiction A about a particular case, doesn't matter what. Jurisdiction A, I want to find rules or something that governs the facts in this case that comes from jurisdiction A. We want to be as close to jurisdiction A's statutes, rules, case law, whatever it is. We want to use that because that's controlling. That's controlling. And so that's the most important. You don't have that sometimes. Okay, so what do? You don't fold up shop. You're going to look maybe in a district nearby or in some similar similar fact patterns in another jurisdiction. But think of it this way: every time you leave home, right, you get further away from having a strong case. When you get further away from that controlling jurisdiction, whether it's on the state level or the federal level, where those rules govern the behavior, it's harder. So what you really love is you really would love, controlling in the controlling jurisdiction. Lots of cases that have been resolved that way. Lots of statutes around that particular behavior. A lot of facts that speak directly to those or fall under those controlling jurisdictions and rules. You want that because it makes your case stronger, right? It's one of the things attorneys will consider when a case comes to them in terms of looking at the facts and what would, what jurisdictional rules, if you will support it. So, adverse authority, meaning that the court has to be made aware of that, or if you're reasonably aware of it. All right. The reference, and this is page 347, this is important. The reference to controlling jurisdiction, that's in quotes, in the disclosure rule appears to flatly exclude authority from outside the forum jurisdiction, even if it is squarely on point. Okay, controlling jurisdiction in the disclosure rule, meaning you've got to bring it up. Only for that jurisdiction. You're not responsible for searching other jurisdictions. We're here in jurisdiction A, and we're aware of this rule that is controlling in jurisdiction A, and that is something that has to be, touched on, right? If an adverse authority does not meet these standards, you need not address it unless the other party relies on it or the court raises a question that encompasses it. In an opening brief, for example, you should not waste time by distinguishing marginally analogous adverse case law or by criticizing poorly reasoned persuasive authority on which the opposing counsel is unlikely to rely. Instead, you should concentrate on affirmatively presenting your own arguments and supporting authority, and you should attack only the most obvious adverse authority. Your responsibility is to make your argument as best you can. And if you're going to attack the other side's argument, you want to do that where they're depending on something that may not have play or as much play in that jurisdiction. So keep that in mind. If you go to law school, they'll point out what jurisdiction it is, and it's going to be a made-up jurisdiction. It doesn't have to be, but it's always best to do that. And it's a made-up jurisdiction, but they'll tell you the rule in that jurisdiction. That's always a tip-off that I'm going to have to address that rule. If you don't address it, it's a major failing. You're going to have to address it. All right, so just keep in mind, you're going to shift from advocacy for your client, right? And you need a formal sort of process and documentation to make the transition to that. And you want to make your argument as persuasive as possible. Keep in mind, whether it's on appeal or not, it's the paperwork that's submitted to the court, right? Because when we talk about legal process, yes, it's important to try and work things out before and the like, as we've talked in those earlier stages. But the legal process really takes full force, and we're most interested in it when we get to the point where we're actually engaging the system, okay? So the next chapter that you're reading is developing legal arguments. Now, this is really, really important. You got to put aside, it's important, what you think the structure should be and what you think is the best way to approach the court, the process. A lot of what people do, it's Bush League, is they're advocating in a way, or they're presenting a case in a way that television shows might do. It doesn't really work that way. Obviously, what you see on TV is not what necessarily happens in reality. There are people that are informing those writers that are familiar with the system, lawyers, what have you. But there's also dramatic and certain elements. So, so long as they're not fudging the rules too much, that's what their focus is. If they're doing that, impassioned closing arguments and the like, all this should be structured. Okay, this is page 350. You ordinarily should discuss or argue discrete issues in separate sections of your office memorandum or brief, right? In other words, we want to be able to have the argument separated for us, right? What are the issues here? Lay those out. Once you go in and you say, it's slightly different on appeal, especially to the Supreme Court, where the justices may be leading the attorneys because they have a particular place they want them to end up. And so the questions that they ask can be leading. We'll get to that. Okay, and that's not the only place. So moreover, your section and subsection headings should show the proper relationship between your topics and subtopics. Starting to sound like an outline? Beyond these considerations, you also must decide, one, which arguments to advance. You don't advance every argument. If you throw as much stuff up there to see what sticks, it weakens your argument step by step by step. You want to be on point. You want to make sure that the argument that you're presenting, right, that you want to advance is well defined and targeted, right? Now, it's interesting. The order in which you present your arguments is important, and the internal organization of each argument is important. Now, think about that for a second. You have to make arguments that are going to advance your position, right? And the order of those arguments. So, for example, do you start with an argument that is less forceful and end with the most forceful argument? Do you begin with the most forceful argument and end at the least important one? Do you put it in the middle? Where do you put it? Now, there's some different schools of thought on this, and each has somewhat of a different impact. You don't, it's sort of like in journalism, you don't want to bury the lead. You want to start off strong, and so people know exactly what you're doing. So you've got this, presentation of your argument, and you've got to think about the various elements of that argument and sub-elements, and how you're going to structure those, and where they should appear in your formal, argument. Preparing the outline, argument by argument, or the brief before you begin writing is critical. For people that are in undergraduate students, this becomes, I won't say scary. It sort of comes back to haunt them. They've always been told to do this, maybe in their writing, organize your thoughts, and so on and so forth. And it's always been difficult because it forces them to really think about what they're doing. There are those people that can just take all these, just throw everything out there, and then sit back and sort of structure. That's okay. Just get everything out, and then looking at the fact pattern, which are the facts that are important to the argument you're making, and say, okay, we're going to move this here. Well, this is really not important. We should put it there. This is really a subtopic of that. Organizing it. The court does not have patience to sit there while you meander through the wilderness and hope that the court gets it. They shouldn't be doing the reasoning for you. And that's another failing of undergraduates. Right? I'll put a lot of stuff up there on the page, and the professor will figure out what I'm talking about. Or it makes sense in my head. Therefore, it makes sense to everybody. That's why it's always good, if you're going to trial, before you go, to have people there that you can argue in your own firm or whatever, argue and make your case to, so you can see where the weaknesses are or how best to approach it. If you think about debates, political debates, for a political office, it's always best to have someone on the other side as you're practicing, knowing how the person you're going to face in the actual debate probably will come at you, so you're prepared for it. You always, if you're going to go up on appeal, especially to the Supreme Court, you can't afford not to be focused, and you can't afford not to be prepared. You get your 30 minutes to talk on each side, but the justices have already read everything. They know your arguments, so they're going to press you. They're going to interrupt you pretty much right after, may it please the court, bang, it's like, well, I've got a question for you. And then you have to address that question. If you're not prepared for it, that could be problematic. Nothing wrong with saying, I would have to look further into the legislative sort of debates on that, or there's an uncertainty around that rule, or we've not really considered that, so I'd like to get back to you on that. Say, okay. But you don't want to say that every single time, right? You need to make your argument respectfully back. And as I said, sometimes the Supreme Court, which is really interesting, the justices want to convince the other justices to join them in the way they're viewing the case, so they'll actually make the argument or help you make the argument. Wouldn't you say that? Well, how would you respond to this? Those justices are performing, I hate to use the word performing, but for each other. They're trying to convince each other. It looks like they're trying to clarify it in their head, and they are at points, at times, but they're also aware that their audience are the other justices. Okay, so what about then choosing a theme and supporting arguments? Okay, a theme is important. What are we saying here? What are we supporting, right? It's the fundamental goal, the fundamental idea that we really want to drive across. If you don't know what that is, you're going to have a problem. Okay, so now I'm on 350 still, right? A professor of trial practice and advocacy emphasizes that this idea means making choices. You throw out arguments that aren't plausible. You pick between the inconsistent legal theories. You call out the weak points. You toss out whatever gets in the way. You discard what doesn't need to be said, even if it doesn't hurt. You don't throw extraneous stuff in there. What's left is tight, lean, spare. It crackles with power because it's undiluted with stuff that doesn't matter. Okay, here's a good example of this. When a client first comes in and speaks to an attorney about their particular issue, attorney wants to know the facts. Tell me what happened. Okay, so let's say they're not speaking to a lawyer on the other side. So we're not talking about a situation where an in-house lawyer at a corporation or a college or wherever, because they all have them, is speaking to another lawyer that they're going to outsource the case to, and that lawyer is going to take the case. They kind of know what's important, but that other lawyer that they're basically giving it to might have other questions and try and pull out other facts. But if we look at the average person that goes in to speak to a lawyer needs to know, okay, so what happened here? Typically, the person thinks that everything is important. It was Tuesday, and I had gone. It was around 11 o'clock. I was a little bit late, but it was around 11. I don't care, unless it's germane, unless it's a little before 11, and that means something, right, in terms of where you're going with your argument. Criminal law case, it was before 11. I've got, just before 11, I've got documentation. It takes an hour to get to the office. I was there after like at 12:05. Therefore, I couldn't have been the one that did this at 11:30. Okay, time's important there. But I don't necessarily care about time, unless it's relevant. So as an attorney's listening, they're removing things. That's not important, that's not important, that's not important, that's not, that may be important. Put that aside. But the person telling the story doesn't know what's important or not, unless it's an attorney on that side. So what they're doing is, they're just telling the entire story. And the first job of every attorney is going to have to be to take that story and get rid of all the extraneous stuff. Okay, that's important, that's important. So this case looks like it's negligence of some sort, comparative or whatever. Negligence, that's what this seems like. So I, as a lawyer, right, they're going to know, okay, these are the elements that I have to prove in order to win on that score. If I can't, there's no point in taking the case, we're going to lose. And I don't want to lose the case. Client spends a lot of money, and it goes nowhere. And in certain cases, of course, lawyers don't get paid unless they win. Okay, so if the lawyer knows where they're going, they're looking for the elements of the law. When you read a statute and you break out the particulars, those are the elements, right? And so you're first looking to say it's it's a burglary. What are the elements of burglary, and have they been satisfied by the facts that depict the actions that were taken? In order for it to be burglary, you've got to meet this criteria. Here are the 3 or 4 things you have to meet. Every one of them has to be met. And so, how do you meet those? How do you define, what that element is, and then the actions that relate to that element? There's enough work there. You don't need to bring in extraneous stuff. It confuses the process. It makes your argument seem weak. It does dilute it. You're taking people out, sort of out of the room and bringing them back in. No, you want them to stay there. You want them to follow you. The judge, the jury, whomever, you want them to follow you. And you want to make your argument precise. The wider you go, the weaker it gets, and there's more points of vulnerability. Right? More points of vulnerability. You want to leave access to those vulnerabilities off the table. So, unlike, again, undergraduates that think if I throw a lot of stuff on the paper, I'll be saying something intelligent, and the grade will reflect that. I can tell you, as someone who's read many of these, it does make the argument weaker. It's like, why are you telling me this? What does that mean? People will write things, again, as I said before, and it's clear to them. It being clear to you doesn't mean it's actually clear. You need others to read it and say, I don't know what you're talking about. When you're speaking to friends, you can get away with, well, you know what I mean. You can't do that here. Well, come on, the court knows what I mean. You don't ever say that. That's an admission that you really haven't organized the thoughts in your head. You want to make sure that you never have to ask the court to figure out what you're talking about. Or for the partners, if you're doing a memorandum, to figure out, what you're saying. It's got to be tight. It's got to be to the point, and it's got to obviously be narrowly focused in order to do those things. So you got to keep that in mind, that choosing the theme and the supporting arguments means getting rid of stuff that you think, oh, that would help. No, it's not just about helping. It's about driving home the theme. Does this carry water or does it not? Does this get us where we need? Does it advance as a step? Well, no, it kind of gives some more meat to the bones. No, does it advance it? Does it advance it or not? So developing that theme, about choosing arguments. Again, I'm on page 350, developing a theme. When making these choices at the outlining stage, learn to outline. You want to go to law school, you want to understand the process, you've got to outline. Learn to outline. Try to develop a theme for your brief, a thread that runs through the fabric of the brief from the statement of issues to the conclusion. Here are the facts, they create these issues, and here's how we conclude them. All right. You call out the weak points, you toss out whatever gets in the way. We've talked about that, right? So if possible, your theme should reflect some facet of the dispute that shows, quote, that your client's position is not only legally correct, but also, and legally correct as possible in that controlling jurisdiction, but also equitably, ethically, and morally right. People say, well, wait a minute, the law is about, we understand, it being equitable, the decision, but where's the guy, and we understand ethical, right? That in terms of, there are legal, as I've read to you and discussed, the bar has certain standards of behavior, right? But the morally right thing confuses people. Do not underestimate the importance of a moral, a moral right, that this is morally right. Why? When they write statutes, when they write regulation, when they write law, they should do that in a manner that's consistent with acceptable behavior, right? That they wrote this for this reason and it's right because, and this violates that. And you can go beyond that. I always tell people, listen to Thurgood Marshall before he was on the court argue in Brown versus Board of Education. There's actually a recording of it. I said before that justices will interrupt a lot, right? The thing about that case is there's an awful lot of silence. And he makes really a moral argument. takes off the table, to get to this point that, okay, these children are not, they're segregated. And his argument, and it's a brilliant argument. I'm sort of jumping over things here, but the argument is, don't worry about them. They're used to it. Now think about that. Most people would go the other way. Look at the damage it's done to them. Look how they're not being treated fairly. So moving that out of the way, where are you going? He made it about us. He said, it's not about that. It's about, is this who we are? Is this who we want to be? Is this what we intend the country to be? If this is not who we are, then we can't have this. If this is who we are, then that's who we are. But is this who we are, or who we, intend to be? Again, you should listen to the argument. He makes it much better than I just did. But, I sort of opened the door a little bit for you. So the morally right thing is great. It's just you got to be careful, because it really could, you really need to know what you're doing. Okay? They've got to be analytically sound. And they have to advance the underlying theme. Now, the analytically sound thing, I think, gets to people. I'm not really sure they fully understand that. That means that the analysis has to be consistent and has to lead, basically, to the same place, which is supporting and advancing your theme. Right? What are you trying to say? That's your theme. What are you building on top of here? That's what you have to do, and then you have to stick to it. And any analysis you make should get you further down the road towards it, or add to it in an important and significant way. So the analytical framework, what you're going to say and how you're going to say it, a strategy for your trial and for an appeal. You're always thinking about where this might go, just like you're thinking about what the other side is going to, what their approach is going to be. In that memorandum we talked about, you've got you're not going to have a partner usually write it, but some other attorney will say, what are the facts? They'll get it. They'll do the research. They'll look at it. And their job there is to say, as I've said, to the partners or whatever, do we take this case or not? And by the way, they're never going to say, or they shouldn't say, we shouldn't take this case. What they'll say, or they should get to, is there's a likelihood that we will not win because, right? There's a likelihood we could, succeed if this, and this. And they'll point out what the issues are, the problems. Here's our strongest argument, but they have a counter to it. And they've got pretty solid support for that. So we either have to address that and overcome it, or accept the fact that we can't win because of the basis of that argument. All right? So the main point, the thrust, the direction, the idea, that you want to convey to the judge, you have to be clear on that. Okay, in the process, it's not just dotting the I's and crossing the T's. It's how you dot the I's and how you cross the T's. Just saying, well, we touched on that, we touched on this, we touched on that. Again, if it's something about, let's say, contracts, and fundamentally you have to have an offer and acceptance, right? I will give you this lecture, you'll give me $10, okay? And then, of course, the rest of the contract would talk about the specifics of the lecture, the specifics of the payment process, and all that. But if you come back and say, well, because I made the offer, this lecture $10, you come back and say, well, I'll give you $9. The offer and the acceptance is no more. Now I've got a counter offer. And now I can reject it, or I can come up with another counter offer. Well, no, I want $9.50. So the fundamental of a contract, the very beginning of it, is an offer to do something for something else. You do this for me, and I'll give you that. That's the way that works. Okay, so you then have to think about that and focus on those particulars. Did the movement to $9.50 or $9, pay me $9, did that really constitute a counteroffer? It seems like it did, but suppose in the past the same work, the same lectures, always went for $9, right? And so you come back and say, well, what about $9? That's what we've done in the past. You say it's just a verbal agreement. Is it really a counter offer, or are you making a point that, look, you charged me this in the past, now you want to charge $10? Are you asking a question, or have you made a counter offer? If you've asked a question for clarity, it's not necessarily a counter offer. I don't see why I should pay $10 when in the past I've paid $9. Up to that point, right, you're discussing it. Then you say, I will not pay you more than $9 like I did in the past. Is that closer to a counteroffer? Well, I will not pay you. Not saying I won't, but if you get down to $9 like you've done, then I'll pay it. That seems more like a counteroffer. The fact that it was verbal. Well, if it's been verbal in the past, does that mean that it's more acceptable now? What about if you change it verbally sort of after the fact? Is that okay? Contracts are meant to be broken, right? You can't design the perfect contract. There's always particulars that could be argued. You can't ever write law or really any legal make any legal argument without there being some sort of room for reinterpretation, misinterpretation, or what have you. You could argue over the word "and" in a contract. You could argue over the word "or." Does "or" mean one, the other, or both? Or do we mean "and," that you must have both? I want ice cream and a cone. Does that mean you can just come back with ice cream? Or can you come back just with the cone? I want ice cream or a cone. And you come back with ice cream and a cone. Have you met the standard for the "or"? Well, ask me where it broke down. The person can choose one or the other or both. And so everything becomes open to interpretation. You don't want to go before the court and play that game. Semantics. Court will look at that, how you put things down on paper and the like, but you don't want to play semantics. You don't want to be cute. You want to have an argument for everything. Remember, you have to think about the theme representing some sort of common sense basis. That's always a good place to start. All right, so I'm on page 351. The defendant manufacturer's brief that used a case here, which I'm not going into, might consistently advance the theme that emphasizes the weakness of the causal link between the product's defect and the plaintiff's injuries. Product defect, someone got hurt. You want it, if you're lawyer for the defendant, the company or whatever that produced the product that the plaintiff is arguing now hurt them, you want to show the causal link is not there, right? The causal link is not there. I'll give you a gross oversimplification of it. I ride a bicycle. The front wheel breaks because of some sort of manufacturing defect. I fall to the ground. 4 days later, I go to the hospital because my knee really hurts, okay? And it turns out that, I was playing basketball 36 hours after I fell off the bicycle. You want to say that. If you're the defense attorney, you want to say, there is an intervening event here. And we can't say that it was the bicycle that did it or the basketball game. We know that the person, that the plaintiff did not go to the emergency room until 2 days after the basketball incident, but 4 days after the bicycle. Now, the other side might argue, well, the bicycle in tandem with, right, the basketball really caused a problem. Had they not fallen off the bike, or I had not fallen off the bike, then the basketball game would not have been difficult, or I wouldn't have hurt myself as much. But now you got murky waters. How much was the basketball, in terms of its influence, or what part did it play in the injury, and what part did the bicycle fall? Now you bring in experts and so on and so forth to talk about it. Remember, you want the theme to give the court, hopefully encouragement to see things the way, you want them to see them. Judicial approach, judicial philosophy, that sort of thing. Another brief might advance the expansion of a common law doctrine. It might do something that moves you into the area of a hotly social debate or about social policy. So it will move. That theme, that's got to be well thought out because you're building everything on top of it, right? So you have to think about what your best approach is. In the case of Brown versus Board of Education, they understood the NAACP and Thurgood Marshall. We can't take this to Congress and expect them to write a law. It'll take too long, it's too costly, and it can be interpreted in 7 different ways. If we can get this into the court and appeal it up to the Supreme Court, they're the final arbiter of the law. That's a shortcut for us. Okay, so they had a few cases before, and then they got Brown. They figured this is really something worth going at. And you make the argument he made. And so it's important. Let's get to determining the order of your arguments. Order is everything, right? Think about this. And this is an example that is very simple to illustrate the point. If a child gets caught doing something and parents call them on it, if they start off with the weakest justification for having done it, that's usually that someone else did it too. As they progress to the more sort of direct, valued argument that really moves their case forward, the stuff in the beginning might just seem or diminish the parents' willingness to consider what comes later. You start off with the strongest argument, and if you don't win on that, you might try and throw some more stuff on top of it. But losing that first argument does not help matters any, right? All right, so here we go. Determining the order of arguments. Consider beginning your argument with a paragraph that states the theme of your brief or that provides an overview or roadmap to multiple arguments that follow. If your brief includes a formal statement of the issues, the organization of that statement should mirror the organization of your arguments. Look, it's a lot better and easier for the court to follow an argument that is structured similarly, right? If you're going to say these are the 4 things and you lay those out, then the first thing you mention should be the first thing you address. It's easier to follow, right? It's easier to follow. And people will say, well, what if they're interrelated? Break them down. Say these are the things we're looking at. Do one by one, and then you can talk about the interrelationship, say, afterwards. Further, right? Furthermore, issue 1 or fact 1 in conjunction with fact 2, further leads us to understanding that this must have been the case, or what have you, okay? If your brief includes a formal statement of the issues, the organization of that statement should mirror the organization of your arguments. To determine the most appropriate order of the arguments, here it comes. You may need to balance neutral analytical considerations against strategic considerations. We can put this anywhere, but how does it affect the strategy of what we're doing? Not all facts or issues are going to carry the same weight. Remember where you want to go. It's like anything else. Think of a roadmap. You want to go from point A to point B. There are any number of ways to get there. So what's driving that? Is it the time that you want it to take? Is it the scenery? Is it other things along the way that you would like to do? So you have to think about what you're trying to do to get to that destination from A to B, and what you expect from that sort of road to get there. Is it getting there the quickest way, the one with least amount of traffic, the one where you go buy your favorite market? Is it the one that's going to take you the longest to get there because you don't really like where you're going? You're heading off to the in-laws and you want to kind of take a little bit more time, or you got kids in the car and they're antsy and you got to get there fast, or you got kids in the car and you're going to stop because it's a long trip, and you're going to do something with them so that they're not so bored, and it's something for them to look forward to. What's your goal? You want to get from A to B. How do you want to get from A to B? What do you value? The strategic considerations are based on varying levels of emphasis associated with different parts of the argument section of the brief. Different arguments, right? and then in the brief, and you want to address those. Organization. If there's two things that are critical here in the process, it's getting the theme and the strategy right, and then organizing it correctly. Remember, before the court sees you, they're going to read the briefs, right? And that being the case, you want to make sure that you impress upon the court exactly, what you want the court to sort of pick up, express that accurately. All right. So internal organization, deductive arguments. Look, premises. If you buy the premises, if you think the premises are true in deductive reasoning, then the conclusion must be true. It must be true, right? So here's an example. All dogs are fun. Harry is a dog. Conclusion, Harry is fun. You can't escape that. All dogs are fun. Harry is in that class of all dogs, so Harry's got to be fun. Inductive is a bit different in that you're looking at those premises and you're making a reasonable assumption about what that conclusion might be. That's the best way to think of that at this point. All right, so when we talk about the deductive reasoning, there are certain acronyms like CRAC or CRAC or IRAC or others that tell you the order you should do things in. So like, for example, in a memorandum of law, you want the conclusion up top. The lawyers reading it that assigned you to kind of look into it and put it all together for them want to know where they end up. Okay, we are likely to win the case, right? Okay, great. Now let me see how you got us there. Or we are unlikely. Again, it's not we're going to lose or we're going to win. We are unlikely to win the case. Then they think, okay, fine. Let me check the work. Let me see the reasoning. Let me see, knowing the controlling jurisdiction. Let's see what this particular lawyer, or associate did. So I'd like to know where you say we're going, and then I want to see how you get us there. If I agree and I follow it, and I say, okay, this makes sense, and they haven't left out, any important facts here, or statutes or whatever. They've got it's rigorously done, it's well organized, and it is comprehensive. And they say it's unlikely that we're going to win. Okay. And they'll give you the reason why. So you go to your client and you say that. The client's an important client, gives you, millions of dollars a year in legal work. And they say, I want you to go ahead with it. I don't care if we lose. It's important that, we fight on this issue because other people are going to come at us with the same issue. And even though we lose, those other people are going to know that it's going to be costly for them to come after us and that we're going to defend ourselves. We're not just going to give them money. As soon as you do that, you'll have a flood of lawsuits. So we're going to go fight this one. And if we lose, we lose. But we'd rather spend, the $150,000, the $200,000 in legal fees so that others that might want to take us on will think, they're going to challenge it. And you better be prepared for a long court run and a lot of money. And that may make people, beg off, right? It's fundamental to human nature. If you raise the cost, people are less likely to do it. If there's no law, if there's no punishment for doing something, then people will do it. It's human nature. It makes perfect sense, does it not? That if I'm not going to pay a price for my behavior, I can do it. If I am going to pay a price for it, I have to weigh that. Is the price I'm going to pay worth the benefit I get out of it? I don't care if you're talking about a schoolyard bully or you're talking about, multi-billion-dollar corporations. They plan a strategy. For example, credit cards. People default on credit cards, or let me change it. People owe a lot of money on credit cards. They decide to go bankrupt. So they go to the bankruptcy court. They do the whole spiel. And now, those banks that gave those credit cards or those corporations that gave out those credit cards have a decision to make. Do we go to court and spend $10,000 in legal fees to get our $1,500 out of this person who is filing bankruptcy and probably doesn't have any assets, and it's really a pointless exercise. So in 90% of the cases, and that's a made-up number, but a vast majority of them, the banks or whoever gave out the credit card, whoever issued it, will just say it's not worth it. They'll not show up. They'll not fight it. But if you owe the local, lawn guy or the local plumber money, let's say you owe them, $300, $500, $1,000, they're likely to show up and say, you have to make them pay me this. There's more of a danger there. Again, you may not show up, but if you know the person doesn't have anything you can get out of them, but you can get a judgment, and you can hold on to that for a long time. But there's a lot of work in that. But that plumber may say, I want other people to know you got to pay me, that you just can't have me do the work and not pay me. So word gets out, does great work, but you got to pay. So it may be worth going to court. No one thinks, well, this bank really lets you off the hook. Well, all the banks do for that. Now, if you owe them enough money, you owe them $10 million, they're coming to court. Or, I can't imagine why they wouldn't. There are cases where they would not. So when we talk about CRAC or IRAC, what have you, it's just how we go about organizing things. And you'll see that it makes perfect sense to organize things in the following way. So let's just talk about CRAC. You got your arguments, and you have to have a way of presenting them. So CRAC is an acronym, and the C stands for conclusion. The R stands for rule. The A stands for application, and then you get conclusion again. Okay, IRAC is issue, rule, application, and conclusion. And there's a bunch of those. It's just the approach you want to take. But they all encompass the same elements. It's just what you do with them and how you, the order should be the same, but how you might prove those things out. So you get some complicated acronyms. But if you go into law school, you're going to see IRAC, you're going to see CRAC, you're going to see a bunch of those. But the idea, the concept we're going to go through is the same, right? Everything has a conclusion. You can't just leave it and say, well, okay, that's it. I don't know what's going to happen here. You've got to conclude something. Again, in a memorandum, you want that conclusion up top. It just makes it a lot easier for those people doing it. There's no suspense. Here's what we're getting. Let's see how we got there. The court, submitting paperwork, it would be somewhat different. All right, so what do we mean by conclusion is just that, where all these facts and our analysis of them and the use of the rules that are germane, controlling jurisdiction, all that, we get here. All right, so the rule is important. You have to establish what the rule is here. Given this case, given these particulars, here's the rule that's been applied, and you have to support that rule, that is in fact the rule. So let's just say you pull a lot of, it's not just enough to have the statute. You've got to pull cases. You've got to talk about, how courts have defined that rule. You need to know what the rule is and the facts that led to that rule in the courts. Okay, that's what you have to do. Now you've got the rule. That doesn't mean your rule applies here. So that means you've got to apply the rule, right? Application, that's the A, or your rule app. Now how do you do that? You're going to have to show how the case before the court, your case, is similar to those other cases where this decision that you want them to make here was made, right? You've got to show that the facts and so on, those cases also apply here, or that rule that those cases support apply here. Or you've got to say those don't apply here because they fail to look at this, and this case has that element, and we need to modify, right? We talked about that already, modify that rule, or maybe replace it. Plessy versus Ferguson, right? Separate but equal doesn't work. Get to Brown versus Board. All right. So let's say the application is done well. You've got the legal facts and the rules and so on. You've got to conclude, right? You've got to say, okay, so this is where it gets us. This is what we have to consider, right? All right. So let's talk now about how to introduce legal arguments. All right. This is the actual structure now. All right. So you've got the idea, the theme. You kind of know what you have to do. You have to work at and look at examples of these various documents and how they've been submitted, and look at how they do it. The best way to learn is to do, and the best way to do is to first prepare to do, and the best way to prepare to do is see how others have done it. right? So if you want to build a house, you want to see how others have done that. So you can see that process. You can see how they do things. If you're going to then go ahead and build a house, you're probably better off getting some experience in doing that with someone that already knows how to do it. So you can kind of see how it's done and you can practice it. And then you can go build that house on your own. You learn, right? You learn how to do things by doing them, but first preparing to do them. All right, so the very first thing you're going to do here in the actual structure is what we call point headings. You'll find this on page 356. For each issue in the argument, again, you've really structured the issues really tightly, section of your brief, you will discuss the law and apply the law to the facts to reach a conclusion. Okay, that's for every issue, that's where you've got to go. There are three things here, three issues, and you've got to do it for each one of those. Okay, before you begin your full argument, however, you will introduce it in an argumentative section heading or point heading, right? In each section or subsection that addresses a discrete issue, your point heading previews the conclusion. A good way to practice this is to take these several pages and just lay them out, point headings. Don't write anything in, just to remind yourself this is the process and this is what this does. The law, again, stock and trade are words, and organizing those words is critical. Do a poor job of it, increase the likelihood you're not going to win. Okay, so so this point heading is like, hey, this is the point. This is what we're going to get to. So who's ever reading it kind of knows. It should preview what? The conclusion. So you know where you're going to end up. The section heading of an argument in a brief, however, always advocates a position by asserting a point and inviting the judge to reach a particular conclusion. Now that's the argument in a brief. You want the judge to sort of, here's what's going on, and you want them to do something with it. If a section or subsection of your argument develops a full deductive argument, premise, conclusion, its point heading should be tailored to the facts of your case, much like the statement of an issue and holding in a student case brief. Indeed, you may view your point headings as statements of the holdings in your case that you want the court to adopt. Point. This is where we want to go. This is what you need to adopt, and here's how we're going to do it, right? So to give you an example here, argument. This is on page 56 still. Okay. O'Gorman is not liable for medical costs associated with Wallace's heart failure because O'Gorman's conduct did not proximately cause that injury. Approximations or proximate injury is important. It means it's related somehow. The basketball, the ride the bike, that's what we're talking about. Okay, now we get to B. O'Gorman is not liable for punitive damages because he did not act with the requisite malicious intent or recklessness. When you talk about looking at punitive damages, right, which is separate, that's the second thing they're talking about. He didn't act with requisite malicious intent or recklessness. In other words, those are two elements that have to be there. Requisite maliciousness, right, intent, and being being reckless, or both, right, the and the or. You got to be able to define that. How do you define what that means? Requisite, or malicious intent is key, or recklessness. How do you define them? Well, it's helpful if they've been defined elsewhere, like in other cases in that jurisdiction. Or you could give some reasonable definition that would isolate how we're going to view those two things, malicious intent or recklessness. You're going to have to define those things. You just can't say, it didn't have the malicious intent or recklessness that's necessary. The court's going to go, okay, why? Why doesn't it have those elements? Explain those elements, define them, show them how they weren't present, because if you define this way, we would expect to see A, B, and C, and A, B, and C weren't there. So, for example, malicious intent. I spoke to 12 people for 2 weeks about how I was going to run over my neighbor with my bicycle because, he stole my rake or whatever. Hey, if you've got witnesses that are willing to say that, that seems like there was some intent there. I've been speaking about it for 2 weeks. Or let's say there was no intent. but I'm riding my bicycle up on people's lawns, down, I'm going in their driveways, I'm turning around, I'm going really fast, I'm doing wheelies, whatever it may be. That's reckless behavior. Recklessness means that you should have known. And by using whatever it is and the way you were using it or doing whatever you were doing, that it was going to cause harm. So, okay, bunch of kids, 17, let's say. If they're 2 years old, they can't possibly be responsible. Seven maybe. So they get water balloons, kind of foolish for 17-year-olds. But let's just say, I'm using the age for a reason. They go up to the 20th story of a building and they're dropping them off. It's reckless behavior. That can hit someone in the head, right, or scare someone. So it comes down right in front of someone and they fall to the ground, have a heart attack, and die. That is plausible that could have happened. What makes it so plausible? Because it did. Now, you'd have to prove the defense that, no, this person was in the throes of having that heart attack anyway. This balloon had nothing to do with it. Proximate cause, right? And so you get a feel for this, right? You're going to use words that are elements of a particular statute, and you're going to have to define them. Another argument. O'Gorman is not liable for punitive damages because he lacked the requisite center, right? So, okay, the jury may be permitted to award punitive damages only when the evidence is sufficient to permit a jury finding of malicious intent or recklessness. You can't give them punitive damages other than that. Punitive damages mean we know that this is going to happen again or could happen again. We don't want this person to do it again. We don't want them dropping water balloons off a 20-story building. So we're going to not just say you've got to pay for that person, what's happened to them. We'll figure out what those damages are. We're going to punish you by making you pay more. So you know not to do this again, because we think you will. The evidence at trial will show that O'Gorman acted in a careful manner and certainly not with recklessness or malicious intent. Carefulness, if you can demonstrate it was a careful manner, you really can't then go ahead and say it was reckless or malicious. Suppose a person had no idea that that what they were doing would cause a negative outcome. It was unreasonable to assume they would have, right? So if that's the case, then it can't be reckless. You'd have to be aware of the fact that this is improper behavior, or a reasonable person would know it's improper behavior. So, all right, the next piece here, after doing the point headings, would be the introductory paragraphs. In the introductory paragraphs, immediately after the point headings, right, I'm doing this in order, but before discussing the legal authority, which is jurisdictional and all that, you may want to use an introductory sentence or paragraph to illuminate the issue and to expand on the point heading or to place it within a larger context. In other words, you've made the point. Now you might want to have an introductory paragraph to that particular issue and that point to sort of, kind of prime the pump. Right? So here's an example of that. This is on 357. The alleged agreement is unenforceable under the UCC, Uniform Commercial Code, Statute of Frauds. Statute of Frauds basically states that, hey, if the job can't be completed, the thing you've contracted for within a year, you need it in writing. And all rules can be, fungible. But statute of frauds means that you have to be clear about what you're doing. So if I can finish the job in a year, I may not need a contract for it. If it's going to take longer than that, you should have it in writing. New York State is very big on things being written out. They sort of want everything. You've got an agreement on anything you want it written, which is a way of avoiding a lot of conflict. All right? So here we go. It says here, the alleged agreement is unenforceable under the UCC Statute of Frauds because it is not evidenced in a signed writing as required for goods priced at more than $500. The UCC, Uniform Commercial Code, is how businesses are supposed to sort of behave, if you will. And this provision about statutes of frauds has certain elements and certain requirements. And they're making the argument here that it's supposed to be for goods and it's supposed to be more than $500. Now they're going to explain it. That's the point. Point heading. Now they're going to explain it in an introductory paragraph. Some printing company denies that it ever agreed to the contract alleged by Scott Paper Supply. The lawsuit presents precisely the kind of groundless contract claim that the statute of frauds are designed to bar by requiring a signed written contract as a requisite enforcement. The Uniform Commercial Code Statute of Frauds generally, what happened here? Generally bars, and they go on. The point here is that they made the point heading, and then under it a little paragraph explaining it. So here's what our argument is going to be, or we're going to center our argument on. But we want to make it clear. We're not just going to give you the point heading. We're going to go ahead and we're going to just expand a bit on it. You don't have to do this part, but it's a good idea for, I think, two reasons. One, it has to clarify your thinking. And two, it kind of begins the process of leading the court where you want them to go. Okay, where you want them to go. Nonetheless, the response normally should begin by stating its counter-argument affirmatively rather than restating the opponent's argument. The introductory paragraph following a point heading can set up your full response by adding more detail to the point heading, thus explaining generally why the opposing argument lacks merit, usually saving citation to authority and all that. What we're saying here is you're beginning to walk the court into the deeper water, right? In rare cases, you may begin with a summary of your opponent's argument if that serves an effective means of revealing the weaknesses in that argument. You might want to bring that up. That, okay, it's $500, and they're claiming that, under the statute of frauds, it was $400. And so it doesn't meet that standard. Okay. You want to use that technique if the opponent's argument sounds extreme. If they sound like they're going off the deep end. Okay, the next thing you want to do is developing that deductive argument. First thing is arguing the law. Remember, we go from examples of law, case law, and even if we have to, debates in the legislative body where they talked about what they were going to do with this statute, with this law, with this rule, and what the intent was. You want to know why they put it together. It's always good to go back and look at that. What did they discuss? Now, in decisions and cases, they'll do that. So you may be able to just look at those cases and get it. If you're thorough and a little maybe too inattentive, you're going to go and you're going to maybe do that on your own. But really, if there are several cases and they've agreed about what the intent was of the legislative body, you can that's consistent with those cases. You ride that out. Again, if you're trying to say the law should be replaced with something new, you've got more of a mountain to climb, and so you may have to dig everywhere you can to see how you can make that argument. All right. So the arguing of the law is important. We'll get into that later in more detail. But what's key here is the hierarchy of authority. Again, I'll make the very obvious and I think not the best argument here or example, but you'll get it, I think, and it's a little bit easier to grab a hold of. So it's always best to build from something that you can get and then get more complicated with it. All right, so the hierarchy of authority. If a child does something, they don't want to quote their older sibling. So-and-so said it was okay to do this. It's better to tell dad that mom said it was okay to do this, or to tell mom that dad said it was okay to do this. That you're appealing to a higher authority. The jurisdictional thing is you don't want to appeal to people that are someplace else, right? The neighbor's house. That's not the controlling jurisdiction. Your house is, okay? All right. The next thing you want to do, so you want to look for the statutory, the order here is statute trumps case law or common law. That's the way it works. If I don't have a statute that I can rest on, I'll go to common law. But statute supersedes common law. So therefore, you analyze the statutes first, right? And then, of course, if it's unconstitutional, that preempts the statute. So it's constitutional violation, right? The Constitution. Then from there it goes to statutory law, and then from there it goes to common law. So you're looking for, obviously, if you're going to make the argument it violates the Constitution, that's more of a mountain to climb, but that would certainly trump any statute or common law. You would obviously say the statute is unconstitutional. And that's because once that falls, then you can't be guilty of violating anything. All right. So when we talk about the strength of case law as precedent, in analyzing case law, looking at cases, regardless of whether it interprets a statute or applies common law, you must appreciate the relative strength of its different kinds of authorities. They go, okay, and they pull in authorities, and you have to say, well, those authorities are not going to advance our argument as much as this other case and the authorities they use, all right? The authorities are the things you lean upon to make your case, right? So case law from other jurisdictions may have persuasive value, but only in the absence of controlling law. Sometimes you got to go outside the jurisdiction. You may have to go way outside the jurisdiction, but every time you move further away from that controlling jurisdiction's rules, your case, it gets harder. It just gets harder to prove, and that can become really, really problematic. I'm going to end there because what I want to do now, next time, is I'll start here just to refresh your memory, and then I want to go through the material that's laid out, on pages 360 and a few pages after that. We'll lay that out for you and show you how all this sort of can work, so you have a better sense of it. In the meantime, I would read further on, so you've already read it before I do it in lecture, and I'd also read up to this point. Stay on top of the reading. If you read before I do the lecture, that's why I give you some time in between. It makes it easier for you, because then you see an elaboration, you can go, oh, that's what that means. If you don't, the first time you're hearing it is from me, you have to go back and look at it and make sure you fully understand it. So we'll end the lecture there. We'll pick it up next time, which will probably be, in another several days.